employee relations, labor relations, employee engagement, terms and concepts, PHR, SPHR, SHRM-CP, SHRM-SCP exams. Part 1. By Human Resource Prep. Alternative Dispute Resolution, ADR. A wide range of dispute resolution processes for disagreeing parties to come to an agreement without litigation. Examples are arbitration, mediation, constructive confrontation, peer review panel, and ombudsman. Arbitration. An ADR procedure in which disputes are submitted to one or more impartial arbitrators for final determination. Arbitration can be voluntary or mandatory, but arbitration decisions are often binding and final. Tripartite arbitration panel. 3 arbitrators are selected to hear a specific dispute and reach a decision. Ad hoc arbitrator. An arbitrator is selected to hear only a single case between 2 parties in conflict. For detailed explanations and many more practice questions, purchase the 1010 PHR SPHR practice questions with 200 PHR/SPHR key points and 2 full practice exams, available on Amazon.com. Also, remember to subscribe and click on the like button. Agency shop. A form of union security agreement where the employer may hire union or non-union workers, and employees need not join the union in order to remain employed, but non-union workers must pay a fee to cover collective bargaining costs, called agency fee. In the United States, requiring payment of agency fees from non-union employees in the public sector is unconstitutional as decided in Janus v. AFSCME. Principal-agent relationship. The principal-agent relationship is an arrangement in which one entity legally appoints another to act on its behalf. This means that regulations on unfair labor practices, ULP, that apply to employers and unions, also apply to the actions of their agents. Ally doctrine. The ally doctrine refers to when an employer subject to a strike uses the employees of a neutral employer as strike breakers. The doctrine states that when a struck employer effectively uses the employees of the ally employer as strike breakers, the union can picket the ally employer, with no violation of the NLRA's secondary boycott prohibitions. Authorization cards. A union authorization card is signed by an employee to indicate the employee's desire for union representation. When the union collects signed authorization cards from at least 30% of employees, the union can petition the National Labor Relations Board, NLRB, to hold a secret ballot representation election. Bargaining unit. A group of employees with a community of interests, who are represented by a union in collective bargaining, and other dealings with management. Bargaining units are determined by the NLRB. Bumping rights. Bumping rights refers to a union contract privilege, granted to a more senior employee, allowing them to replace a less senior employee. Bumping rights are typically exercised when a reduction in workforce results in the elimination of the more senior employee's job. Cat's paw principle. Under the cat's paw doctrine, an employee seeks to hold his employer liable, based on the discriminatory intent of a supervisor, who was not responsible for making the ultimate employment decision. Certification of representative. The certification of representative is the formal document that certifies that a labor union has been selected as the exclusive representative by a majority of the employees in a bargaining unit, from valid ballots cast in a secret ballot election. Certification of results. NLRB certification, indicating that a union has lost an election. The chilling effect. The chilling effect refers to situations where employees refrain or hesitate from engaging in their NLRA rights, for fear of running afoul of an employer act or regulation. Circuit City Stores vs. Adams. Court case on whether the Federal Arbitration Act applies to contracts of employment. The Supreme Court ruled that a pre-hire employment application, requiring that employment disputes be settled by arbitration, was enforceable under the Federal Arbitration Act. Civil Service Reform Act. The CSRA reformed civil service in the U.S., and created 3 new agencies: the Office of Personnel Management, OPM, the Merit Systems Protection Board, MSPB, and the Federal Labor Relations Authority, FLRA. The CSRA extended collective bargaining rights to federal employees.
To get the full explanations for each question, as well as 1010 practice questions, 200 key points with an analysis of key terms, 2 practice exams, Purchase the 1010 book on Amazon.com, link in the description box. Also check out the description box below for additional resources towards earning the PHR, SPHR, SHRM-CP, and SHRM-SCP. Facebook Practice Group, Class Marker PHR SPHR Practice Exam, books on Amazon, and the teachable PHR SPHR online course. Remember to subscribe and click on the like button.
Clayton Antitrust Act. The Clayton Antitrust Act of 1914 sought to prevent anti-competitive practices in American businesses. The act restricted the use of injunctions against labor unions and legalized peaceful strikes. Closed shop. Closed shop is a form of union security agreement, where membership in a union is a condition for being hired and for continued employment. Closed shops were made illegal by the NLRA, except in the construction industry. Coalition bargaining. Coalition bargaining is a process where more than one employer negotiates with the union. It is also called multiple employer bargaining. Codetermination. For international labor relations, codetermination refers to employees having the right to vote for representatives on the board of directors in a company. It also refers to staff having binding rights in work councils on issues in their workplace. Collective bargaining. A process of negotiation by which management and union representatives negotiate on behalf of employees in respect of terms and conditions of employment, such as wages, hours of work, working conditions, grievance procedures, and the rights and responsibilities of the unions for a designated period of time. Collective bargaining agreement, CBA. A collective bargaining agreement is a written legally binding contract, negotiated through collective bargaining, that regulates the terms and conditions of employees at work, inclusive of wages, benefits, duties and responsibilities of the employer and employees, and a dispute resolution process. Common law, the part of English law that is derived from custom and judicial precedent, rather than statutes. Common law is often contrasted with legislatively enacted, written laws. Common situs picketing. This is where an employer's work site that is targeted for union picketing is also the work site of another employer. This will unavoidably affect employees and employers who are not involved in the labor dispute. Therefore, common situs picketing is subject to special rules. Top-down communication. Communication from top management, which makes its way down to the workforce. Bottom-up communication. Communication that flows upward from a lower level of an organization's hierarchy to a higher level. Lateral communication. Lateral or horizontal communication takes place when employees at the same level interact. Community of interests. Community of interest is an important criterion used by the National Labor Relations Board, NLRB, to determine whether a group of employees should be allowed to act as a bargaining unit. It refers to similarity in skills, interests, duties, and working conditions, and mutuality of interests among employees. Compressed workweek. A compressed workweek schedule allows an employee to work a traditional 40-hour workweek in less than the traditional 5 workdays. For example, a full-time employee scheduled for 40 hours per week could work 4 10-hour days instead of 5 8-hour days. Conciliation. A non-binding alternative dispute resolution (ADR) process, whereby the parties to a dispute use a conciliator, who meets with the parties, both separately and together, to resolve their differences, by lowering tensions, improving communications, and assisting parties in finding a mutually acceptable outcome. Conciliation differs from mediation mainly because it works at restoring or repairing the relationship, business or personal. Consent election. A consent election is an election in which an employer and union agree to waive the pre-election hearing. Consent elections are generally held if there is no substantial issue in dispute between the employer and unions involved in a representation case. Constructive confrontation. The constructive confrontation is an ADR approach that seeks to resolve the underlying causes of intractable conflicts by separating the core issue from non-core issues. When non-core issues are resolved, the core issue can be seen objectively and resolved more readily. Constructive confrontation takes an incremental, rather than a holistic approach to deeply rooted conflicts. Constructive discharge. Constructive discharge occurs when an employee resigns as a result of the employer creating a hostile work environment. Consumer picketing. Consumer picketing is used by unions to inform consumers that the goods were produced by an employer whose employees are on strike. It is used to urge customers not to purchase products from the business. It consists of activities, such as distributing handbills, carrying placards, etc.
We offer a standardized online course for the PHR and SPHR. PHR-SPHR self-study course on Teachable.com. The course includes basic, intermediate, and advanced resources designed to enable you to earn the PHR and SPHR exams, with over 1,000 standard questions. Check out the link in the description box below. And with that we come to the end of today's lesson. Check out the description box below for additional resources towards earning the PHR, SPHR, SHRM-CP, and SHRM-SCP. Facebook Practice Group. Class Marker PHR, SPHR, Practice Exams. Books on Amazon. Teachable PHR, SPHR online course. Remember to subscribe and like this video.